The title of our lecture is The Beginning of Legal Personality. We are dealing here with the commencement of legal personality, especially for a natural person. When does a natural person become a bearer of rights at law? Does a fetus have rights at law? Is it protected in terms of the law? What is the basis for the protection of a fetus? Is it in terms of rights or in terms of certain recognizable interests? These and other issues are from the crust, or let me say the gist of this lecture, and we are going to be looking at these issues in the next slides. Now for some background issues. The enjoyment of legal rights is reserved only for legal subjects, and it is only legal subjects who have that interest or those rights. So legal subjects consist of natural as well as juristic persons, and in terms of the common law, only living persons are entitled to legal rights, since legal subjectivity only commences at birth and terminates at death. So in terms of the common law, a fetus doesn't have legal rights. It is not a legal subject. It may have legal interest, but it certainly doesn't have legal rights. And this was confirmed in the Christian case, or Christian lawyer's case, in 1998 as well as 2005. Now, certain acts done before the birth of a natural person may sometimes have consequences on the life of that person later on in life. And what legal principles have been used to resolve issues connected with the rights or interests of the unborn? We ask ourselves these very important questions to say, are there any legal principles that we can rely on when we are faced with questions of the rights of unborn persons or fetuses? Now, there are quite a number of other questions that I would like us to give attention to. What should be the relevance of pre-birth circumstances, acts or omissions in the life of a person? Should a person subsequently born after the commission of acts or omissions not be allowed recourse to the law concerning those acts? And what are some of the rights and interests affected by the legal position regarding the commencement of legal personality? In other words, the South African law has a certain position regarding when a legal personality commences. And then, so we are asking ourselves the question, what are some of the rights and interests that are affected by the position? And we are saying, in which cases of the law, or in which areas of the law is it relevant to determine exactly when legal personality commences? Quite a number of objectives now must be fulfilled in the course of this lecture. We are saying by the end of the lecture, participants should be able to list the fields of law in which the subject of the commencement of legal personality is relevant. They should identify and explain the principles employed in order to resolve issues around the commencement of legal personality. They should also explain the nasciturus fiction and its relevance in the protection of the prenatal rights and interests, and then evaluate the effectiveness of the fiction in protecting the fetus in utero, that is a fetus or a baby inside the uterus of its mom, in matters of property rights, inheritance, delict, and criminal liability. And then we must also be able to identify its limitations in resolving the recent legal questions dealing with prenatal rights and interests, such as wrongful life and wrongful birth. Outline the tensions between the fetus's interest to live and the rights of the women to abort in the exercise of their reproductive health choices in terms of Section 12(2)(a) of the Constitution of the Republic of South Africa, and also be able to analyze the relevance of the nasciturus fiction in resolving issues based on those prenatal interests. So these are some of the issues that we are going to be dealing with. We've got quite a number of cases and a number of some literature that is available that you should just think about as you are preparing to take a journey to study this area, interesting and lucrative area. It says we have the expert Boydell Steenkamp case of 1962, which determined, among other issues, whether a fetus or an unborn was entitled to inherit tested and intested from a grandfather who died after its conception but before it was born into a fully fledged human being. Then we have the pinching in another versus the Santam Insurance Company. This one deals with delict. And then we have the Christian Lawyers Association versus the Minister of Health, 2005, as well as the 1998. There are two cases here dealing with whether a fetus is a human being or it's a person anticipated in terms of Section 11 of the Constitution, whether it had any vested rights that should be protected. And then we have an issue of a case of murder, whether a fetus can be murdered. Then we have an issue of, again, delict in the Road Accident Fund versus Mutati. This case dealt with circumstances almost similar to those of the pinching and another, but it reached a different verdict, a different decision, particularly regarding the national fiction and its relevance. And then actions based on wrongful life and wrongful birth have also come up recently, as we can see in the H versus Kingsbury Fetal Assessment Center in Cape Town. It's not a reported case, but it's a very, very important case, so one could say. Now, you should also think about the choice on termination of pregnancy, Act 92 of 1998, and think about, if you have time, just read the Pickles. It's written by Pickles C, an article on the termination of pregnancy rights and fetal interest in continued existence in South Africa. The Choice on Termination of Pregnancy Act 92 of 1996. So these are some of our resources that we'll be paying attention to. Now we have scenarios there. Some women obviously expecting, and then look at them. What rights do they have? What obligations do they have? Taking into account that it is only women and not men who are able to fall pregnant, are there any specific rights and interests that must be accorded to women, particularly on matters of determining their choices and reproductive health choices and so on? Take a look at the scenarios that we have here. Nelly is a 17-year-old grade 11 learner who is 11 weeks pregnant and considers terminating the pregnancy in order to continue with her studies. Will she be allowed to abort the fetus on demand? What rights does she have? Would Nelly's quest for an abortion be viewed differently if she had reached 32 weeks of gestation? And what factors would be considered in taking the decision whether to abort or not? Meanwhile, Nelly's father, who died last week, left a will wherein he nominated all his grandchildren who are alive at the time of his death. Will the child, that is the fetus, be entitled to the inheritance if he's later born alive? Now, take another example. Charlene's marriage has been unstable because her husband has an extramarital affair with another woman. Now she's 38 weeks pregnant, and her gynecologist just confirmed that the fetus is in good health and she's due to deliver any time. And then on her way home, she is ambushed by men who shoots at her womb, specifically targeting her fetus in the uterus. And apparently, the assailant has been sent by Charlene's estranged husband. Although she sustained severe injuries, she gets treated and then discharged, but the baby is not so fortunate. Now she wants to know if she can press murder charges against the perpetrator. So we are looking here at whether a charge of murder is competent. It's a competent charge at criminal law in respect of termination of the life of a fetus. Mr. Thabo, whose pregnant wife was knocked down by a motor vehicle, wants to sue the driver of the vehicle on behalf of his own son, who was born with mental disabilities, which medical doctors have attributed to the accident. And he wants to know if there are any claims that lie against the driver whose negligent conduct caused harm to his unborn son. Then, last but not least, Mr. Thabo's wife, Tricia, had instructed her doctor to terminate the pregnancy soon after the accident because she feared that the baby would be born with disabilities and emanating from the accident. The doctor did not adhere to the instructions, as a result of which a disabled child was born. And now, does Tricia have any right of claims against the doctor? And if so, on what basis can she make the claims? Now, there are areas represented here by the scenarios above. For instance, we have the choice on termination of pregnancy, where we are looking at the pregnant grade 11 learner who decides whether to terminate the pregnancy or not. And then there's the issue of the tension between the rights of women versus the rights of the unborn to be born alive, and whether the unborn have any such right to be born alive, as well as the permission for abortion in the first and second as well as third trimesters. What interests are at stake there? And then there are issues of the inheritance by a fetus. Is a fetus entitled to inherit? And then what are the delictual remedies available for prenatal injuries? And what about the issues of wrongful birth and wrongful life actions? How does the law of South Africa treat these cases? Such activity. Read the cases listed above, and well, they are below, incidentally, and then identify the case which applies to each of the scenarios. You remember the scenarios that we gave earlier on. We have cases of the expired Boedel Steenkamp, Pinchin and another versus Santam Insurance, the Christian Lawyers Association versus Minister of Health, and then the S versus Mashumpa, and then the Road Accident Fund versus Mtati, as well as the Kingsbury Fetal Assessment Center, H versus the Kingsbury Fetal Assessment Center. So we are saying that each of these cases applies to one of the scenarios above. So you read each of the cases in an effort to identify how, rather, the critical principles that are raised and deliberated within that case, as well as how they influence our understanding of the law regarding particularly prenatal life. You must also take time to read the Constitution of the Republic of South Africa, Section 12.2a, which says everyone has the right to bodily and psychological integrity, which includes the right to make decisions concerning reproduction, and everyone has a right to security in and control of their body. And this is best understood if read together with the preamble of the Choice on Termination of Pregnancy Act 92 of 1998, and you must identify the tensions between the interests and the rights being balanced in the Act. Identify the relevance of the principle of viability in determining the cutting points or the cutting stages for the termination of pregnancy, whether at first trimester, second trimester, or third trimester. So you are saying to yourself, what are those important factors that influence legislative decisions around termination of pregnancy? Um, as you can see, there are a lot of issues that need to be covered here. We could not cover all the factors or all the scenarios, but this has just been an introduction which will hopefully lead to a further study. If you follow up on everything that we've covered here, you should be able to get at least foundational understanding of the issues around, or the main issues around the subject of the commencement of legal personality.